Yo, what up to the crew, man? Hey, I'm finna put some on you so cold, man. Alright, man, today's video this might save so many people's lives, this one video alone, bro. This one video right here might get a whole bunch of people out of a jam and totally change the course of their life, which is what I'm about in the first place. I'm not just trying to impact one person's life, somebody I personally know. I'm trying to impact everybody's life on some real stuff for the good, though, on some real stuff. But look, though, this information right here, man, this is very dangerous to the course. This is very dangerous to the corrupt system that they got going on. These commercial courts, these are not lawful courts. These are commercial courts, bro. These judges, these prosecutors, this is dangerous information to be out. So if anything happens to me, bro, y'all better go hard for me, bro. Y'all better spread this message, G. Y'all better put on for me. Y'all better go hard, bro. Y'all better tear this down, bro. Tear this down, bro. Like for real, bro. Cause y'all can't just let me go out like that, bro. For real. But first of all, yeah, this is about court stuff. This is about the government being exposed, bro. And this is about breaking down the court system, bro. Because if you can force them to have to establish jurisdiction, which they won't be able to do lawfully, bro, then you can get yourself out of a lot of messes, bro. So, you know, let me zoom in a little. Let me zoom out. It's too far. I didn't even zoom. Oh, I zoomed all the way out, I guess. Alright, anyways. So what this video about today is to show you how to enforce your right to a fair hearing and to win. You know, if you go into court fighting a ticket or a victimless crime. This is for victimless crimes, bro, when there ain't no injured party, fam. So this ain't advising you to do this or telling you to listen to me. Like I said, fam, I do not give legal advice. This is just legal information. This is just what I would do if I was brought into court. I'm not advising you to follow this. I'm not advising you to try and repeat this. This is just what I would do. This is just legal information. This is not legal advice, bro. So basically, so you in there, you in the court, and they trying to go in on you. So you really need to know what to say, because everything you say gonna be used against you. That really means something. That this language is full of spells, bro. So you need to memorize this in your brain, fam, so that your tongue can speak it at will. You feel me? So you can be prepared for any response that they might come at you with, because you always got to be in control when it comes down to this plan. You feel me? You cannot let them take control. So look, the first appearance you make in court is your arraignment, in which the purpose is to get the court to present the charges to you and find out how you intend to react, basically by standing up for your rights, or they seeing if you're gonna be fearful or be like an easy target. You feel me? So like during this proceeding, the judge is gonna inform you of the charges against you and attempt to get you to enter a plea of guilty or not guilty. A third choice is no contest, which is essentially pleading guilty without admitting guilt. So be careful, because as soon as you open your mouth to enter a plea, you giving them jurisdiction basically over you. And if you intend to follow my procedure and win, then you can't be entering no plea. We do not plead, fam. We do not get on our knees. We do not plead, you feel me? So the first question the judge probably gonna ask you is probably gonna be something like, do you understand the charges against you? Or it might be, how do you intend to plead? You gotta let him know, like, no, I do not understand, and I cannot enter a plea until I get some questions answered. The judge probably gonna get irritated, and he probably gonna start trying to intimidate you, you feel me? You gotta politely state, like, you got some questions that you need to be answered before you can plead. Tell him that you do not understand the nature of the cause of the action against you. Once the judge has agreed to answer your questions, then your first question gonna be like, look, is this going to be a civil action or a criminal action? In a highly unlikely chance that the judge answers your question by saying it's a civil action, your response gonna be, thank you, Your Honor. Let the record reflect that this is a civil action. Your Honor, since this is a civil action, I make a motion to dismiss for a lack of sworn complaint by an injured party, and no injured party is present. Most likely, the judge stated that this is a criminal action. You feel me? So you respond, "Thank you, Your Honor. Let the record of the court then show that the action against me is a criminal action. I have another question, Your Honor. The Constitution grants this court 2 different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these 2 criminal jurisdictions does your court intend to try me?" Don't panic if you don't get the article, section, and clause remember right away. You'll have them down by the time you go to court if you just keep on watching the video, studying the video. By the time if you practice and you got it down and you aren't afraid of getting it wrong, then go ahead and do it like it's nothing. But if you are afraid of getting it wrong, it'll be wise to have some brief notes with the clause number in it and, you know, the article, all that stuff, you feel me? If the judge gives you a specific answer, you again say, "Thank you, Your Honor. Let the record of this court then show that the action against me is a criminal action," under which whatever jurisdiction he replied, you feel me? So it's either going to be common law or the admiralty military tribunal. So it's going to be one of those 2. But don't expect an easy answer from that question, because now you just exposed the court's fraud, because they're never going to try you under common law, you feel me? Which is basically, if there's no injured party, there's no crime, you feel me? The truth is that they are acting under a military tribunal, under which they have no right to use with you in the first place. But the judge can't say that. And he can't say common law, because if he does, then you will make a motion to have the case dismissed, because there's no sworn complaint by an injured party and no injured party present. So that's exactly like you would do if it was a civil action. So if he said, "Oh, this is a civil action, a civil complaint," then you will motion to dismiss. It's the same exact thing you would do at this point, because there's no crime here. So when you protest that there's no injured party, if the judge is silly enough to say that the state of whatever state that you're in is the injured party, then say, "Your Honor, I make a motion that this case be dismissed, as we are in the wrong court. If the state is a party to the case, how can the state be a party to their own case?" You feel me? They cannot also be the judge and the prosecutors. So this case needs to be transferred to federal courts or be dismissed. Most likely the judge will try to avoid entering and will tell you to get a licensed attorney for such legal advice. Your response will be, "Your Honor, but I don't think you'd be violating your oath if you did your duty under the Constitution. You see, I'm not seeking legal advice." And by the way, like I said, I'm not giving legal advice. I'm saying what I would do from my perspective, or how I would train my son to go in and defend himself. "I'm not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. And in order to intelligently defend myself, I have to know the jurisdiction that this court is operating under. Because the rules under criminal procedure of common law jurisdiction are very different from the rules of criminal procedure under admiralty or military tribunal. I need to know under which jurisdiction you intend to try me in order for me to proceed with this case. The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me, and I don't think you be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified?" If the judge responds by telling you to get an attorney, is that a loose dog? Oh no, that man good. If the judge responds by telling you to get an attorney, your answer will be, "Thank you, Your Honor. Let the record of this court then show that I, whatever your name is, the accuser in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of the action. Furthermore, let the record also show that this court intends to bring this action against me under a secret jurisdiction known only to licensed attorneys." ooh, you done got him now. You burned him now. At this point, the judge might claim that this is a statutory jurisdiction under the statutes of whatever state you're in. If he does that, your next statement is, thank you, Your Honor. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. But Your Honor, that raises another question I have. I have never heard of a such thing as a criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. I will be happy to accept this, Your Honor, if you can please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction and where this nature, cause, and jurisdiction information exists. It is imperative that I have the published rules of procedure so that I may conduct a fair defense in a fair trial. But at this point, let me put the light on. You got to keep in mind that the judge made up this jurisdiction. There is no granted authority for a statutory jurisdiction and no published rules. But don't expect him to tell you that. A judge will never tell you that. He got to either lie, dismiss the case, or unlawfully enter a plea on your behalf. In rare cases, he might even threaten you with contempt of court and might try to throw you in a room for 24 hours until you say sorry or something like that. If he threatens contempt, then say, Your Honor, I do not wish to be held in contempt. I am simply trying to exercise my Sixth Amendment right with you, that you disclose the nature and the cause of the charges against me. I can provide court citations that show that the exercise of a constitutional right cannot be converted into a crime. Please either identify the properly established jurisdiction, or I make a motion that you dismiss this case against me. Also highly unlikely, but still possible, is that the judge would tell you when you ask under what criminal jurisdiction that you're being tried. He'll tell you straight up that's an admiralty jurisdiction or military tribunal jurisdiction or law, maritime jurisdiction, something like that. If this happens, then I or you will respond as, Your Honor, let the record of this court then show that this court intends to proceed with a criminal action against me, whatever your name is, as a condition of contract under an admiralty jurisdiction as a military tribunal under Article 1, Section 8, Clause 17. However, Your Honor, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered into any international contract, so I deny that any such contract exists. Will you please instruct the prosecuting attorney to inform this court that there is a such contract, if there is a such contract, and if so, to place it into evidence and explain how I am a party to it and then compelled to perform under it. If the prosecution cannot do so, Your Honor, I make a motion in this case that it be dismissed. Of course, if at any time your case is dismissed, you feel me, because it can be dismissed anytime before this, you feel me, then you got to make a pronouncement saying, thank you, Your Honor. Let the record of this court reflect that case number blah, 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 against whatever your name is, has been dismissed. Now you got to leave quietly, you feel me? And you got to save all your boasting and bragging and all that stuff you want to do. You got to wait till you get outside the courtroom to do that, you feel me? And if at any time you feel a good opportunity to make a motion to dismiss, you feel me, then make it. Even if it wasn't part of this prepared script or your prepared script, whatever the case is going, you feel me? But you got to be able to be flexible and jump on any opportunities that may present themselves, you feel me? So let's say the judge has had enough of your questions and he decided to help you out by entering a plea of not guilty on your behalf. Like, all right, I'm just going to enter a plea of not guilty for you. Immediately you got to object. Like, I object, Your Honor. For you to enter a plea on my behalf is basically you practicing law from the bench, and you can't do that. So you got to let him know, I object for you to do that, because that's practicing law from the bench, and entering a plea is my job or my attorney's job. So has the court made a judicial determination that I am not guilty? Now you got him in a trap, because now he's basically said you're not guilty, but now you can't let him say that you're playing not guilty. So you saying that he said that you're not guilty, and now he has to say yes, that he admitted that you're not guilty at this point. Well, he really doesn't, but at this point you kind of trapped him. So state, "Thank you, Your Honor. Let the record of this court reflect that the judge has made a judicial determination that I am not guilty of the charges against me. Therefore, I make a motion that this case be dismissed because the judge has determined that I am not guilty." If he says, "No, I have not made a judicial determination," then you make a motion that the plea be withdrawn and that you be allowed to enter your own plea once you know the nature and cause of the case pending against you, because he still hasn't told you which jurisdiction this is under. So you don't even know how to properly defend yourself. If the judge enters a plea of no contest, object. And you got to say, "Your Honor, I object for you to enter a plea on my behalf, because that is practicing law from the bench, because entering a plea is my or my attorney's job. I make a motion that the plea be withdrawn for you to make a judicial determination that I am entering a plea of no contest. And that will result in the court treating me as in I had pled guilty. The court is trying to constrain me in an unfair play choice in the absence of my understanding the nature and cause of the charges against me." Or let's say the judge instead gives you a continuance and he demands you go get a licensed attorney. You feel me? Go get a licensed lawyer or a licensed attorney under the bar association, something like that. Then you ask the court, has the court made a judicial determination to deny me my right to defend myself in my own person and to force me into hiring a licensed attorney that will conspire with the court to try me under a secret jurisdiction known only to the judge and the licensed attorney? So look, if after all this, if you walk out this hearing without a dismissal, then you got to ask for a motions hearing, or you can ask to have motions heard at the beginning of the trial. But to ask for a motions hearing shows the judge that you're not just going to be railroaded. You're not just going to bend over for him. You feel me? So you got to tell him, like, there's some pivotal key issues that need to be resolved in order for me to continue, and that these motions must be heard prior to a trial. At a motions hearing, you cannot, there's too many animals out here. You can't be found guilty, but the case can be dismissed, so it's in your favor. Either way, when the motions are heard, they must stand on their own and be heard and ruled separately from the rest. Don't just hand over all your motions at one time and let him just say all are overruled. Make him rule on each one separately and individually, like individual cases. Now, let's take this from the top in a manner in which it will probably happen. It might not, but this is the way it probably will happen. Do you understand the charges against you? No, Your Honor. I need you to answer a couple questions. I do not understand the charges against me. No, Your Honor. I do not understand what's going on. You remember the word understand is bad. That means you're standing under the charges brought against you. So you're questioning, I don't know what jurisdiction this is. Is this a case going to be heard under the civil jurisdiction or criminal jurisdiction? He says criminal. Okay, because if he says civil, you dismiss right there. Thank you, Your Honor. Let the record of this court then show that this action against me is a civil action. Now I have another question, Your Honor. This Constitution grants this court two different criminal jurisdictions. One is a criminal jurisdiction under the common law, and the other is a criminal jurisdiction under admiralty or military tribunal, or maritime military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution. In which of these two criminal jurisdictions does the court intend to try me? If he says something like, if you don't understand the law, then you need to hire an attorney, that's when you hit them with the same thing again. You're just going to keep running them in circles like they keep trying to do us. Thank you, Your Honor, but I don't think you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is legal intent. I have the right to appear as myself in my own person without a licensed attorney. And in order to intelligently defend myself, I have to know under which jurisdiction that this court is operating, because the rules of criminal procedure under a common law jurisdiction are very different than the rules of a criminal procedure under an admiralty or military tribunal. I need to know under which jurisdiction you intend to try me in order for me to proceed with this case. We're just going to keep running them around. They want to waste our time, we're going to waste theirs. The Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me, and I don't think you'd be violating your oath of office for doing your duty. Therefore, will you please answer the question so this court is properly identified? He might say, finally, this is a court under statutory jurisdiction and the laws of this state, of whatever state you're in. That's when you're going to let him know. Thank you, Your Honor, because we're being polite. You're not going to be rude. You're going to be polite. Let the record of this court then show that it intends to conduct a criminal action against me under a statutory jurisdiction. But, Your Honor, that raises another question. Yes, I have another question. I have never heard of a such thing as a criminal action under statutory jurisdiction. And there is no such reference in the Constitution. I would be happy, glad, joyful to accept this, Your Honor, if you could please tell me where I can find the published rules of criminal procedure under a statutory jurisdiction and where this nature, cause, and jurisdiction information exists. Again, it is imperative that I have the published rules of procedure so that I may conduct a fair defense and a fair trial. Again, he might say, all right, I'm just going to enter a plea on your behalf and set the trial date. I enter a plea of no contest. You must immediately object. Your Honor, I object for you to enter a plea on my behalf. Why? Because that is practicing law from the bench. Because offering a plea is my or my attorney's job, which I don't have one of those. So it's my job. I am my attorney. Don't say all that though, but you know what I mean. For you to make a judicial determination that I am entering a plea of no contest will result in the court treating me as though I had pled guilty. The court is trying to constrain me to an unfair plea choice in the absence of my understanding the nature and cause of the charges against me. I make a motion that the plea be withdrawn and that this case be dismissed because the court has failed to identify a legitimate jurisdiction. He might say, I deny that motion. Your court date will be at such and such a date. Boom. Your Honor, I would like to request that we set a motions hearing prior to the trial date, as I must resolve some pivotal key issues in order to continue. And these motions must be heard prior to the trial so that I can properly defend myself. Boom. We're going to keep it going just like that. When you get to the motions, you gotta run them circles again on them. You feel me? Now you might have to pull out at this point. If they don't dismiss the case at this point, even before the motions case and this and that, I don't know if you want to mix it all up because you can still get them on a jurisdiction and all that stuff in the motions. But I don't know if now will be a good time, because when they trying to identify you, that might be the point where if you have an assumed name filed, or assumed name, and on top of having an assumed name, if you have your name copyrighted, if you have the passport card, if you have proof that you're a state citizen or American national, if you got, which you can go get the proof from the passport website, you can, I think it costs about $60. You can have them send your passport records to you, and they'll send you back the application that you filled in, that you filled out, you feel me, which will serve as proof that you are a national, because they accepted this information and still gave you a passport, you feel me. So when they're trying to identify you, that's mainly when you got to pull out all that other stuff. But if they get past that part of identifying you by your name or your all capital letter name or whatever the case it is, this is where I would use this, where now they have to establish jurisdiction, because I'm going to challenge jurisdiction. I want to challenge your jurisdiction, and since I challenged it, you have to establish jurisdiction. Again, this is not legal advice. This is legal information as to what I would do if I was brought into court, or if my son or one of my children was brought into court. So I'm making this video for the sake of, if one of my children come across this video, now they have instructions for me written down, because anything can happen to me at any time. I might not always be here, but hopefully they'll have this video as instructions for me to my children. You feel me? Because I can instruct my children. But for everybody else, I'm letting you know that this is not legal advice in any way. This is just my legal information as to what I would do. This is information as to what I would do if I was brought into court on a non-violent crime, on a crime that doesn't involve an injured party. There's no injured party. No living person coming against you saying this person injured me or my property in such and such a way. You feel me? So again, if you've watched my video called Government Exposed, whatever, it got is like 40 something minutes long, whatever, it got all them views on it, then you probably already kind of understand where I'm coming from. If you haven't seen any of that, or even seen this, then you might not understand at all. You might not get the point, like, for real. You might be like, what is this dude talking about, like, seriously? So you might have to go watch that video before you really understand this one. But again, this is not legal advice. I am not a licensed attorney. I am not a licensed lawyer. None of that stuff. This is just what I would do if I was brought into court, or these are instructions to my children if they were brought into court. This is how I would instruct them to conduct themselves. But all right then, I'm up out of here, man. Like, comment, subscribe. Make sure y'all subscribe, man. Hit that like button. Make sure y'all spread this video everywhere. Y'all don't know how many people this can help. Put it all over your Facebook. Put it all over your Twitter, all over your Snapchat, Instagram, all that stuff. You don't know who this can help. I'll release a cleaner version later. This was kind of rushed. I kind of been busy all day. I'll release a cleaner version later, but for now, y'all got this. One of my mans is in something right now, so I thought I'd drop it right now. You feel me? I'm out.